Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
We are now entering into the first thematic session. So now I'm going to invite our distinguished moderator, L Viswanathan, partner at the Cyril Amarchand Mangaldas. The first panel is on intersections, rule of law as the edifice for business. May I invite the panelists, Sidharth Sharma, Sara Ellis, André Birotte, Jenny Rivera, Todd Eddins, and Michael Wilson to kindly come up to the stage.
Thank you, Raj, and thank you, Mr. Shroff, for this wonderful opportunity. Very distinguished, panel here. Yeah, so it's a very unique opportunity for us to engage with you, and thank you very much to the distinguished panelists for that. My first question to Sidharth. For the guests from the United States, Sidharth is the General Counsel of Tata Group, which is a very reputed and well-known industrial enterprise, in India, ranging from different businesses. So the question for you, Sidharth, is rule of law and its relationship with economic growth and justice. As a country, we have an ambition to be a $5 trillion economy. What is the role of judiciary you see in that? There's sort of data and statistics about pendency in India having an impact on GDP. But isn't the conversation and debate beyond what is the economic impact of judicial decision? I still think the country considers our judiciary as one of our brightest institutions. So how can judicial effectiveness augment economic growth and development?
Thank you, LV. First of all, I'm truly honored to be here. A bit nervous in this company. I'm not sure if I have earned a seat at this table, and truly honored to have all of you in the audience, and I have this opportunity to speak before you. I only derive strength from the fact that I come from an organization, the Tata Group, where perhaps I think all of us would agree India's greatest lawyer, Mr. Nani Palkiwala, used to sit. I sit in the same building, and to that extent I can shine with reflected glory. Mr. Palkiwala was perhaps again the biggest champion of rule of law. He fought for rule of law and constitutionalism all his life. So that's my little connection with this subject. Now, coming to the topic, of course, LV, I think the importance of rule of law cannot be overstated. And I, as a student of law and also from a business house, I would look at it at three levels. First level is, have we articulated or asserted rule of law as an abiding principle, as a principle of governance? And answer is yes. We are a constitutional democracy, and we have perhaps one of the most elaborate written constitution, and therefore it goes without saying that rule of law as a principle is hardwired into our system. Our Indian Supreme Court has taken it to another level. Rule of law has been declared as part of the basic structure of the constitution, and therefore the power of judicial review which our constitutional courts have cannot be taken away even by the parliament. And our apex judiciary has asserted itself, has protected it steadfastly. So on that count, I think we'll get full marks. Similarly, innovating new legal principles or articulating new legal principles which establish the rule of law principle. For instance, our Supreme Court has held manifest arbitrariness as a ground to strike down a law. Now, that is nothing but a principle of rule of law being asserted. And therefore, at this level, on this count, I think we should get full marks. And what Dicey, in his articulation of rule of law, the third limb, he said the predominance of the spirit of legal principle. I think we are there. Now, the next level is, and where I speak now from the perspective of a business house, is that at the most basic level, what is that most basic outcome that a rule of law framework or a society provides or one expects from? And that, I feel, is predictability. When you enter a country, when you invest in a country, when you do businesses, the minimum that you want is predictability. And business houses, they work with assumptions. As a business lawyer, we have to advise that if scenario A happens, you have remedy B and you will have outcome C. But on this count, I feel that perhaps we have more to do. It's not a question of intent. Perhaps it's mostly a question of capacity. We have a judicial process which is slow, and therefore, at least in procedural matters, end outcome no one can predict, but procedurally and how a situation can be addressed to the legal process, we can't predict perhaps at the same level where say a US lawyer or a UK lawyer can predict in matters of enforcement of contract, in matters of enforcement of arbitral awards. Because we have a slow process, it is difficult to predict that outcome to your constituent. Now, of course, the problem is of capacity. By any standards, our judges will be the most overworked judges in the world. And therefore, that is a problem that we have to solve for. And what it leads to, and that can vitiate or subvert rule of law principle, is that then you look for alternative solutions. Then somebody will try to game the system. Somebody will say, do you know somebody? Or you will go for suboptimal solutions. Now, from a personal experience of a case that I handled personally, was that in a taxation matter, very interesting question of law. We were very confident that we must fight it, and we took it to the Supreme Court. It was argued over 6 months period. Judgment was reserved, and then unfortunately one of the judges on the bench, he superannuated, he retired. And then we were told that it will have to be reheard, but you didn't have insight when that rehearing will take place. And in the meantime, government came out with a settlement scheme where you could pay the 50% of the tax liability and settle it. Now and we did it because you could not predict that when this rehearing will take place, what will be the outcome, and therefore you went for this suboptimal solution where a tax, which I believe we should not have paid, settled it. So on this count, I feel that from a business perspective, we have to do much more. Now, the third level is what Mr. Shroff was alluding to, that how judiciary plays a proactive role in aiding and advancing rule of law. There are newer issues like climate change, artificial intelligence, privacy, the whole the data boom that is happening, how we administer taxation. Foreign investment, we are inviting foreign investors into the country, and how do we administer our tax laws. All this, how the judiciary is playing that proactive role in advancing the rule of law. Today, we have the most important commercial court in the country is a tribunal. It's a company law tribunal, which has company law jurisdiction, competition law jurisdiction, and also the insolvency jurisdiction. Now, it's not one tribunal, it's tribunal all spread across various states, and you do not have that consistent outcomes. And therefore, again, in insolvency matters, the most important commercial court in the country, you have inconsistent outcomes, which is not desirable. The other aspect is, again, the whole PIL jurisdiction, where Indian Supreme Court, our constitutional courts, devised this unique, innovative method where they did away with the conventional concept of locus standi and went for this impact justice delivery, where court went beyond this adversarial adjudicatory role and became more inquisitorial, where it called for reports, it appointed committees. Our whole environmental law has developed through this process. And therefore, there are debates whether courts should go into policy matters. Courts should decide how telecom licenses should be given. Whether courts should go into a question of the height of a dam on a river. So all these questions our Supreme Court has gone into, and it is debatable where courts should touch upon matters of governance, which is more intuitive, or whether they should confine themselves to only reasoned legal questions. And this is more a question for all of you, that how US courts deal with those questions. Personally, I am a votary of a stronger judiciary as compared to a very strong executive. And therefore, I feel that this jurisdiction, this proactive role that our courts play must be there, and it's a desirable thing. Thank you.
Thank you, Sidharth. The point you made about predictability as an important element of rule of law for growth of business is well made. We'll touch upon separation of powers, in the panel. Let me request the views of Judge Jenny Rivera. Judge Jenny Rivera serves as the Associate Judge, New York State Court of Appeals. The question for you, Judge, is today we are seeing businesses growing. businesses are fledging, and largely because of innovation. And that obviously means people are pushing boundaries, whether it is e-commerce, whether it is technology, and you have regulators apart from the judiciary who have a distinct role in regulating these emerging businesses. Often it's the case that the laws are not clear. For example, when Uber was launched, there was no specific law dealing with those type of businesses. Today, for example, as an example, the FTC in the US is dealing with several such new businesses and seeking to potentially stop the growth of those businesses before even they are into it. It's almost like a pre-clearance before they launch into the business, or they're being stopped before launching into the business. How do you look at this principle of regulators looking at new businesses? It's definitely not the principle which Justice Lalit alluded to. It's not judicial review. Judicial review is post decision making. But today we are in a position where, and it's happening in India as well, it's happening in US as well. What is the new institution of regulator? It takes the shape of competition commission, it takes the shape of securities regulation, it takes the shape of Department of Justice or other equivalents in India. What is this new institution? What's the role of the judiciary? And how is the judiciary going to protect the business against these institutions? Thank you, Judge.
Thank you for those questions. Again, good morning. It is an area, the questions that you have posed is on a topic and an area which I'm very interested in and which I have decades of experience with. Because before, I didn't mention it during the introductory comments, before my appointment to the court, I was a law professor for almost 20 years. And one of the areas I taught in was administrative law and the regulatory state. So it's an area of particular interest to me. The reality is that in the United States now, we are seeing dramatic changes in the way the US Supreme Court analyzes the role of the regulatory state, the authority, the power of agencies, whether they're independent agencies within the executive branch, to be able to, quote unquote, interpret and provide guidance on statutes. So it is an area that is developing, and we may very soon, I think my colleagues would probably agree with this, it's a prediction, but I think we see the writing on the wall that there is going to be a sea change in administrative law in the United States. We have a case that's been in place for decades, Chevron, which really sets a tone on the deference that the courts give to agency determinations in deciding what the statutes mean and putting into effect particular rules and regulations, and then the interpretation of their own rules and regulations. And whether or not what we call the Chevron deference rule will continue moving forward is uncertain. But it does appear that the US Supreme Court is very interested in revisiting this particular case and perhaps giving less deference to the agencies. So it may very well be that at least at the federal level, and then we have state judicial interpretations of what the regulatory state at the state level can do. It may very well be that very soon we are going to hear from the US Supreme Court as to whether or not the judiciary is now going to be much more involved with oversight over the regulatory state, or will continue in some version of a deference model to regulators. So that is a very exciting area of the law. It is a contentious area of the law because I don't know if it's exactly the way you're posing it, but of course there is the ongoing debate about whether or not regulation suppresses business and innovation, or whether or not regulation is necessary to address the monopolistic tendencies that you sometimes see in new businesses, new areas of creativity, new industrialist or attempts at industrialist models, the development of these new industrialist models. So you have what I think is a very simplistic debate in the way I've presented that binary, right? Regulation is good, regulation is bad, let's get rid of it, let's increase it. That to me is a very simplistic, not sufficiently nuanced approach to the regulatory state. But it is something that we cannot ignore. For those who think we are going to get rid of all the regulators, I think they are wrong. That is not, we cannot run a government without some form of regulation. You may reconsider and re-envision that regulatory state. You may have new models, you may have new ways of thinking, well, who should be the regulators and what role, getting back to really the issue at hand, right? What role should the judiciary play vis-a-vis these new regulators? But nevertheless, you've got to have some form of regulation. I don't think that's the judiciary. I don't think judges should be super regulators. This is nonsensical to me. Not to mention, apropos of your point over there, it will mean we are completely overworked. It will mean we cannot do the rest of the business of interpreting statutes, the Constitution, enforcing, ensuring that the law is properly enforced. We will not be able to do that. So the reality is that we are going to have a different kind of model, I think, moving forward. But in my view, the role of the judiciary is, as you had mentioned, of course, there is judicial review, that post-decision making of the regulator. There is judicial review of the regulators' structure of rules and regulations, the way they interpret those rules and regulations, the way they enforce those rules and regulations for those kinds of entities that have enforcement power, the majority do. And then what happens when you have a change of the guard? Because that's also a very exciting area of administrative law and the regulatory state. What happens when the executive changes? What happens when even your elected officials, right, sort of for us, the Congress, or at the state level, the Senate and House, when they change and they have a different view, perhaps, of the regulatory state? They may have a different view of what to do with burgeoning business models. So in that sense, the judiciary has to bob and weave, if I can use that phrase, through those changes and figure out, well, is it a change that retains some consistency? Yes, there are policy changes. We understand that that's not within the judiciary's domain, but is there some consistency? Is there some explanation for the change? Because you do have, even for us in a regulatory model, you do have some precedent that's set within an agency. We, for the most part, don't allow fully arbitrary and capricious agency decision-making that vacillates from one day to the other, because you lose the consistency, you lose the predictability. Not to mention, it appears to us from the judiciary to not be something that is reasoned. It may not be the reason I would have chosen, but there has to be some reason for the change beyond just, I'm the new executive and I just don't like it. There's got to be something that informs the model so that businesses can continue to grow and continue to provide the kinds of services that we all need. Because, of course, why do we even have businesses? Yes, to profit, of course, but also to serve us. It's in the service of humans. And so we need to ensure that businesses can go about that business. With respect to the judicial review that falls to us, again, we may see a sea change on how much deference we're going to give, but otherwise we're bound by some basic, we use fundamental, but some foundational tenets, let me put it that way, in the law. And so I had mentioned New York and its primacy as a global financial center. Some of at the state level, some of our tenets, of course, are that we respect the fact that business players, business parties can arrange their business how they wish, as long as they do not violate public policy. You know best what you need. You know best how to make it happen. You go put the lawyers in the room, let them duke it out. You go have the CEO and the COO figure it out, and then you put it in writing. And when you have a dispute, because surely you will, something will always go wrong, you will bring, as you were saying, you will bring that dispute to the courts if you can't resolve it yourself. Now, you are correct, and we see it in New York, the growing need for an alternative to the judicial branch to help address the continuing disputes that arise within the business community, especially in these new business models, because it's a brave new world. First of all, you're asking what will be the dispute. Sometimes you do not even know what you're going to disagree about. You think you've got common ground, and then moving forward, you find you disagree. But in any event, so we do have lots of mediation. We do have lots of alternative dispute resolution, looking for these other venues. But in New York, we also have, and some of you may be familiar, what we call a commercial division. So we have, in that way, a specialized part of our Supreme Court. For us, the Supreme Court is the trial court alone. So we have a commercial division, and we have a minimum amount in controversy. So the commercial division handles the bigger kinds of cases. And it also has judges who, of course, sit in these parts, and they are experts in these areas. So the attorneys who go before them know that they're getting a judge who is well-versed, well-informed, and well-experienced on these issues, and who intends to move the case along. The point of the commercial division, also to address a point you raised, is to ensure that these cases don't get caught in the backlog that may happen in the courts when you have lots and lots of cases. Because again, this is one of our principles, that we want to ensure that business is able to resolve its disputes efficiently through a consistency in our law, but quickly as we can. It doesn't always happen, but as quickly as we can. I know my time is running out. So last point I'm going to make on this, and I hope we can continue the conversation, is the other principle as a global center, is the recognition, again, that apropos of what you asked, that businesses can, in that developing model, become monopolistic. And that anti-monopolistic principle is one that guides the entire US, but certainly guides New York State. So it is a continuing balance, how to promote business and ensure that we are not standing in their way. We have some consistency and predictability and rules of procedure and evidence so that people can anticipate how a case will go, but at the same time, very cautious that there's not the gaming of the system that you were talking about, or the opportunity for one business to get rid of competitors. That's that anti-monopolistic principle, because business thrives through competition. That's our model, and that's what we ensure through our judicial system. Thank you.
Thank you, Judge. Just a very quick comment before I go to Judge André Birotte. I think as we all understood our separation of powers, we have the judiciary, we have the legislative, branch, and the three branches: executive, judicial, and legislative. Now you have the regulator who's coming in every way. Earlier we just had, the police as somewhere in between. But now you have a new body called the regulator, which has all of these elements embedded in one institution. I think that's the challenge we are going to face as we start unpacking, the regulation. Thank you for your comments. So may I request Judge André Birotte to speak about how do judges deal with innovation today? And I'm inviting you to speak about this because you're from California and center of innovation. Today we find every business is dealing with innovation, whether it's education, whether it is technology, medicine. How do you, as a judge, how do the judges deal with innovation when these matters come up before? And may I request you to, keep it to 5 minutes if you can.
Sure. Look, it's an important question and a challenge, quite frankly, because we're dealing with issues that many judges are not as familiar with the subject matter, but we're being presented with them for the first time. When you just talking about artificial intelligence, many judges do not have that prior experience. Many of the litigators don't have that experience, and so they're all learning in some ways as we go. And I think a good friend of mine who's a litigator dealing with artificial intelligence and looking at issues about, does the data, is it being scraped from the internet, and what laws are implicated from it? Contract law, copyright law, and judges are going to have to analyze and interpret that. But it's interesting just hearing from the justices from the Supreme Court and my friend right over here, judges are going to have to make those decisions and in some way be innovative, just like here in India dealing with privacy, the right to education. Judges are going to be presented with these new innovative technologies and having to make decisions on them. It is a challenge, and I can't comment necessarily which way it's going to go, because quite frankly, these issues may come before any one or all of us in the near future. But I think our foundation is to look at the jurisprudence, look at the statutes to the extent they are applicable, and make these important decisions. Much like, though, that's what our role and responsibilities, I would argue, are. Judges have done this for decades. When you talk about going back in time, the civil rights movement, privacy, antitrust, judges get presented with these issues all the time. And in some ways, we have to rise to the occasion and try to meet the issues that present itself. But it is a challenge, no question about it. And I think in many ways, I joke with my colleagues, I feel like we're building the plane as we're flying because these issues are so new. And I'm learning them, the lawyers are learning them, it's an educational experience. But, the hope is that that's what we're entrusted to do and make those decisions.
Thank you. What you said, Judge, makes me feel better even in front of clients. Thank you, Judge, for that. May I now invite Justice Michael Wilson. He's already been introduced, to everyone. I think his special theme and focus has been climate change. May I request Judge Michael Wilson to talk about what was his thought process? We're all aware of the contribution you've made to the development of jurisprudence on climate change. Do you see, you heard the debate about Article 21 of our Constitution before the beginning of the session. Environment, occupying its sort of pedestal there as well. Can you talk about your remarks about abdication of responsibility by the federal judiciary and therefore the state judiciary having to step in to protect climate change?
Thank you for getting me to obsess about the issue that has taken up so much conversation in Hawaii, and looking at it in the context of Article 21, for example, the issue of climate change, the future, and the extent to which the state courts will participate. So let me diverge to Article 21, which represents heart, right to life, then the right to a clean and healthy environment, then the right to privacy, the kind of recognition of a duty that I guess one could consider to be to stand up for the culture and stand up for the part of the community that might be suffering is there. In the United States, what's happened is we have a rogue Supreme Court that has gone in a different direction, taken away a constitutional right for the very first time, the right to abortion. Now, if you move to the kind of chemistry of discourse that we have here in this room, which is remarkable and historic, to have, icons, titans of the law, the justices that are here, formerly the Supreme Court, mixed with the power of your empire, Cyril. And then I look into the audience and bring the conversation in terms of the chemistry of this discourse. What are we feeling? What is the rule of law at this point in history dealing with emergency and the participation of the state court? I think of the young associates I met when I came in here. And do you know how many children there are in India? 444 million. They are front and center for the decisions that the state courts and the federal courts are making. Now, in the federal court, you have the diversion of the Supreme Court into an era in which there is this enormous abdication of responsibility to recognize the rights of future generations to a stable climate. It's a natural thing. It hasn't happened yet in India, but I predict that the Supreme Court, what is a more fundamental right with respect to the right to life? The right to privacy or the right to a stable climate capable of supporting human life? If you're thinking of 444 million people in your country, most of whom are poor, who are going to more and more be facing the lethal conditions of a preventable condition, of course, you can see the Supreme Court of India moving in the direction of recognizing such a right. Not our Supreme Court, but we will get some great dissent, and we've had some great courage on the part of federal judges. One very brave federal judge pointed out that the federal courts have too often been deferential and hesitant in enforcing environmental rights, and the world has suffered for it. That's from an opinion. Another great judge of our federal courts has said, and I'm standing up a little bit for federal courts because basically they are the biggest threat to, I think, the welfare of future generations in the world, the federal court decisions that are coming out. But another great federal court judge has said that it's like an asteroid that's about to hit Earth. That's the level of emergency. And that was said in the course of a dissent to a federal court at the appellate level. It's a very high level, the Ninth Circuit, saying, no, we can't possibly have a right to a life-sustaining climate for young people because the remedies are too complicated, which really doesn't make sense if you think about the kind of remedies that are available. So the state courts have had to step forward and pick up the mantle of the rule of law. The rule of law that is completely dependent on science now. You consider what Secretary General of the United Nations has said about India and Hawaii, because we are on the front line. He said, we are on the road to climate hell. One of the chief diplomats in the world using that kind of language. And then he said, and our foot's on the accelerator. Over 100 million people are going to leave Bangladesh and have to start moving to India. Mumbai is going to flood in 30 or 40 years. We're going to lose our major city that creates over $1 billion worth of commerce every single year in Hawaii, Waikiki in 40 or 50 years. But the children and the women of this world are the front and center claimants, justified claimants on what? The rule of law. They deserve it. They deserve that protection. So the excitement of being in India is that, yes, there is this history of judges with independence and a proven independence. It's exciting when you come from a country that has the leading court going in the opposite direction. And the other thing is the number of young people. I mean, I have the pleasure of working with Raj and Jindal and seeing in 10 years an institution grow, be built, and become the leading law school in the country. So there's hope for people that are 40 years old or younger, people that are focused on this issue. For young people, there's no legal issue other than this, if you're thinking about their families. And so the extraordinary potential of so many young people participating in engines of education, engines of integrity, engines of hope, because that's what's needed most by young people. They can be rightfully cynical and give up if they think that, like, for example, the powerful community in this room doesn't think about the kind of transformational change through the rule of law that's necessary to protect them. But not at Jindal. There is that hope, and not in India. So, yes, we face an emergency, but we're in India, a country of hope. And in the United States, we have state courts like my beloved colleague here who wrote the most powerful environmental climate rights case in the United States. And it's, I think, going to be a trend. We've had the state court, a brave state court judge in Montana, in Held versus Montana, just within the last 4 months, make a decision very much like Todd's decision. And it's not just Todd's. I mean, it was, a unanimous decision of our court, but the decision that he wrote is just amazing. Thank you for the chance to obsess about that. And I'm happy that we can look to India to provide us with guidance going forward. Aloha.
Thank you very much, Judge. And I'm just going to read a paragraph from the opinion which Justice Michael Wilson wrote. The stark failure of the federal judiciary to grant redress to present and future generations, alleging knowing destruction of a life-sustaining climate system, relegates implementation of the climate rule of law to state judiciaries. Thank you for that. My next question is to Judge Todd Eddins. Judge, this is one of my favorite questions and something which has been bothering me for a while. Let me start with our Indian Constitution. We have concept of fundamental rights, but that's essentially an assurance given by the state to the citizens. So in our parlance, we will call that as a vertical protection, vertical rights. But the role of the state is diminishing, as all of us can see it. Over a period of time, yes, state will be relevant for law and order, policing, and whatnot, and public, welfare and public order. But as economies grow, you have new non-state actors. Non-state actors in a commercial sense. You have big tech. You have rising businesses. What is the relevance of these protections to a citizen if you can't enforce them against the new world order? And can we call this? Will this come within the concept of horizontal rights? Are we ready for some form of protection to be given to citizens against companies? In India, what we have done is, at least where corporations take up public service or public utility projects, so the courts have expanded the concept of state to instrumentality to bring them in. But I think this will require a very different approach. So love to hear your thoughts on horizontal rights versus vertical rights. Thank you, Judge.
Yes, thank you. And Justice Wilson's being giving too much credit for what credit's due. In the decision he's referring to, good law builds upon other good law, and you folks are very fortunate to have the good law that was built upon by our court. It wasn't just me; it was Justice McKenna and Justice Wilson also their input into this decision. But also the fundamental aspect on the decision that we've been talking about was written by Judge Staten and Judge Aiken, and that's what we built upon. Had they not set the path in the federal system in their just wonderful, incredible writings, we would not have probably had the insight to do what we were able to do on the state level. Judge Aiken started it with her opinion in the Giuliani case, and Judge Staten's dissent in that case when it got to the Ninth Circuit Court of Appeals were just so awe-inspiring. That, and also Justice Kumar and some of his writings that Justice Wilson shared with me informed a lot of what we had decided to do in our opinion. So it was just, that opinion was just built upon, you know, the legs of just strong judges. And so that's the federal system. Now the federal system, as Justice Wilson just said, has become rogue in our country, and I consider it a lack of judicial restraint. Mr. Sharma talked about that earlier, judicial activism, judicial restraint. The federal system that we have now really wants to set us back to 1791, back to the time of Marbury Madison, which was a wonderful decision. But they want to shrink wrap our Constitution and say that we have not progressed into a modern era. So things like the right to a stable climate system, the right to a life-sustaining climate system, which were the words of these two great judges that we riffed on, is nowhere to be found, apparently, in the United States Constitution all of a sudden. And that is really just a shock. And so it's not only the Roe versus Wade that was overturned, and there's the Second Amendment decision. It's just, it can go on. And we just hold our breath now every June of every year and what the Supreme Court of the United States might do to wreck things. So that's a very unfortunate situation. Now, what's the remedy? The remedy is the state courts now. And as far as the horizontal integration, it's really good old-fashioned torts. I mean, it's the common law system of good old-fashioned torts where the individual can come into court to be heard. There's access to justice issues. There's legal recourse with the ability of an individual to come into court and say, hey, look, what are the traditional court remedies? Strict product liability, duty to warn, negligent duty to warn. You got private nuisance cases and trespass actions as well. Now, the public nuisance, that's more for state and local governments suing. We're seeing a fair amount of that in the United States as well, where state and local governments are suing the fossil fuel industry. But the individual, those suits are exploding all over the United States at the state level. We can't count on the federal, sorry to my federal colleagues, but we really can't count on you anymore. But it's not your fault. It's our I think, a benighted Supreme Court that we right now have in our country. And it's really alarming in what's going on. But so it's really, you know, the state common law misrepresentation. So the fossil fuel industry, as far as the claims go, it's, you know, they knew about the dangers of their product, and they knew about it a long time ago, and that they failed to be warned about the injection of their products into the commerce. So they're basically purveyors of harmful products. They knew about it. They cast doubt upon it with the disinformation campaigns that extended decades, as far as undermining scientific research, legitimate research into the dangers of greenhouse gas emissions and the effects on our climate. And those suits are now progressing in our systems. Now, it remains to be seen, you know, the federal system and even many state court systems have obstacles in place to stop these suits. You know, things like your procedural hurdles, your standing issues, preemption issues. It remains to be seen when some of these state court judgments actually happen, and I think they will happen, whether those cases are appealed to the federal level and whether the federal system comes in to stop some of these suits. But currently, there is a huge movement in the United States to use the basic court system to hold fossil fuel and other industries accountable for the dangers that they knew about and the disinformation campaigns that they existed. So that's a really wonderful question, and thanks for asking that.
Thank you, Judge, for giving us the conceptual basis for approaching horizontal rights. My final question on the panel to Judge Sara Ellis. The question to you, Judge, is judicial impact assessment has been sort of spoken about early on. There are pros and cons of doing something like that. Do you see benefits of doing judicial impact assessment sort of more outweighing the disadvantages? Do you see that as a check on the independence of the judiciary or having to be more accountable? Would love to hear your comments on this topic. Thank you, Judge.
Thank you. And thank you for that question. I think as a judge that it's very important for us to reflect on how our decisions will impact the business community. And one of the ways that if you don't even think of it as an individual decision or an individual opinion, but how you approach cases as they come in the door. And when we talk about rule of law, that it's very important for judges to, especially because I sit like Judge Birotte on the district court, so on the trial level, where we look at active judicial management. So how do we manage these cases? Do we say hands off and we let the lawyers do whatever they're going to do? Where sometimes we get some gamesmanship, right? Or do we take the approach of active judicial management? And I do think that the rule of law requires that level of management, in that you set expectations early on. You hold status conferences on a regular basis. You say, this is what you have done over this period of time. You tell me, what can you do between now and the next time you come in? And then hold people accountable to what they say that they're going to do. And that you move the cases through so that we don't have the backlog that will slow things down. That when you have this backlog, it advantages one side or the other, right? Some people will say, let's go as slow as we possibly can, because maybe we'll wait you out. Maybe we'll put things in a position where you're going to have to send it, because that's your best alternative. It may not be what's right or what's just or fair, but that's the best way to just be done with it. And if you have a judge that, we're not calling it judicial activism, right? But active management, in that that is your role. Your role is to move these cases forward. Your role is to ensure that in the United States, in these civil cases, we have discovery. The discovery is proportional to the needs of the case, that you don't have one side or the other asking for everything under the sun, that slows the case down, that drives costs up, that when we talk about access to the courts and access to justice, if it is so expensive to litigate the case, then people don't bother. And they will just go ahead and find the most expedient way to get rid of it. That's not justice. So if somebody comes to me and says, I need, I want you to go back and look at emails over the last 7 years. I want you to look at 20 custodians. We don't know what terms we want you to use. That doesn't make sense. And I'll say, no, we're not going to do it that way. And for judges, it is also our responsibility when we talk about technology and innovation, is that we need to understand how these things work, right? So it doesn't, I need the lawyers to go back and understand. They can't just say to me, well, I don't know, right? I'm going to go back and ask my client. No, if you can't explain to me why you need what you need and how you're going to get it and how you're going to ask the other side to get it, then bring somebody in from the company, your IT person, to explain to me, how are we going to do these searches? How are we going to do them efficiently? And I need a basic understanding on how those work so that I don't get played, right? And people don't create all these gains because I haven't taken the steps that it's my responsibility to understand how the technology works. Not to the level where, you know, I can go and run these things, but that I can have directed and efficient conversations because, you know, we don't want to highlight efficiency over justice or fairness, but I think that efficiency goes hand in hand with justice and fairness so that people do get their day in court, that cases do move forward, and that we are consistent, and that businesses can come in and rely on a very predictable and consistent way of getting their disputes resolved.
Thank you, Judge. Thank you, Judge.